Thursday, everybody. Welcome. Today we're going to talk about a interesting topic. Nope. My eyes are burning, so I'm just going to put these on. Okay, today we're going to talk about an interesting topic. I don't know if I'm going to be able to cover all of it, but I'm going to try at least to cover some, and then if there's still some left, we'll do it next week. We're going to talk about common immigration myths. So sometimes people will come to me with for kind of a consultation, but they'll come and they'll say, this is what I want to apply for. And sometimes I'll be like, where did you hear that? That is not something that actually exists. And I come to find out that among the immigrant communities, there are some common myths that go around. I don't know exactly where they originated. Sometimes it's just a misunderstanding. Sometimes it's the dealing of not very ethical immigration practices. Sometimes it's the dealing of a pure fraud. But these are things that are considered to be common immigration myths. So let's talk about one of my favorite myths. I would like to apply for abandonment green card. The abandonment green card does not exist. I'm gonna say it all the time, many times. There is no such thing as abandonment green card. If you're married to your citizen and your relationship just breaks down, or your husband or wife just leaves you, your ability to apply for a green card leaves with them. Now, having said that, I have come to understand that a lot of people, when they say abandonment green card, kind of referring to what's called VAWA, which is a Violence Against Women Act. The name is a little misleading, but it applies to men and women both. And the most common situation it applies in is if you're in a relationship with a U.S. citizen or a green card holder, and you're in a marriage and you have been abused in that relationship. And I don't mean just physical abuse, can be emotional, physical, financial, emotional. A lot of the times it's not just one factor, it's a few different ones. So if you have been abused and your relationship have broken down, or you left the spouse because of the abuse, then you can apply for what's called a VAWA, right? Violence Against Women Act. However, if your husband or your wife said to you, I just don't want to be in this relationship anymore, I no longer am in love with you, this doesn't work for me, without any other forms of abuse or mistreatment, there is no such thing as abandonment green card. Sometimes relationships don't work out, but the whole point of getting a green card based on marriage to a U.S. citizen or a green card holder is that showing that you're in an actual legitimate valid relationship, and that person passes kind of along the immigration benefit to you. Also, misconception about VAWA. You don't just prove the abuse or show abuse, you still have to show that the relationship was a valid, real valid real life marriage that was not entered into for the pure purposes of obtaining a green card. Okay, so that is number one, is abandonment green card. That does not exist. Number 2, 10-year green card. That one is so prevalent, and we see it so often. People come to me. Yesterday we had a consultation and a person said, I've been here for 10 years. I entered with a visa. I want to apply for a 10-year green card. The idea that you can apply for a 10-year green card has arrived from a process called cancellation of removal. In and of itself, the fact that you've been in this country for 10 years does not entitle you to a green card. In fact, in and of itself, it doesn't entitle you to any benefit at all. What people commonly refer to the 10-year green card is a form of defense from removal. Meaning, if you have been here for 10 years, and after 10 years, you somehow ended up in front of an immigration judge by either being arrested by ICE or by applying for some sort of benefit that was denied, and you end up in proceedings, and your notice to appear in court was issued after the 10 years of you being in the United States, we can assess your eligibility, the hardships and stuff like that, but you may be eligible for what's called the cancellation of removal. And one of the main requirements for the cancellation of removal is for you to prove that you've been in this country for 10 years. So again, I just want to repeat, just because you came 10 years ago and you've been in this country for 10 years, that does not mean that you're entitled to a 10-year green card. There's no such thing as just a 10-year green card based on the fact that you've been here for 10 years. It's a very prevalent, common misconception that comes to us all the time. Okay? Criminal record. This is an interesting one. So, as you know, recently New York has legalized marijuana. Now, the legalization is still not fully implemented, and there are many different parts to the actual bill that was passed. In fact, if you're really interested in it, you can go to our website, cohentuckerlaw.com, and our latest blog was dedicated to that statute that legalized marijuana, and it talks about various implementations and, more importantly, the consequences for immigrants who have previous convictions for marijuana possession or even intent to sell, covers a lot of different statutes, right? So the common myth that I'm referring to is the following. My people come to me and I say, have you ever been arrested? And they say, no. So then I ask them, have you ever been fingerprinted? And let's say a person says, yes. And I say, well, if you've been printed, how did it happen? A lot of times it comes out that a person says, well, yes, I was charged, but it wasn't a felony, it was a misdemeanor. So, and another times a person will say, no, I wasn't arrested, and I don't have to tell you I was arrested because my record was expunged. This is a very common misconception, but for the purposes of immigration law, even if your arrest has been expunged, it will show up. Immigration will dig out and will see the arrests that have been made to be non-existent or not seen for the purposes of employment, housing, getting a loan. So for civil purposes, those arrests may not show up in your background, but immigration will see them, right? If you look at the common forms, such as the green card application, and when it asks you, have you ever been arrested or have you ever been convicted, it actually then goes to say that expungements, certain vacated convictions, depends, will still be counted, right? So immigration will take your prints, and this is another thing people don't understand, that every single benefit, immigration benefit, from a green card to a work authorization to naturalization, they will take your prints, they will run it through the system, and they dig out arrests from the 70s, which recently happened to a client of ours. He was arrested in the 70s, and the immigration was able to pull those files. And nowadays that so many states have been digitizing their files, their archives going back 25, 30, 40, 50 years, it has become even more common that the immigration sees arrests from decades and decades and decades ago. Now, another common misconception is that if the state doesn't pull it out, doesn't pull your arrest, that immigration won't. Sometimes we will run a background search based on prints through the state system and nothing will come up. Immigration will run based on fingerprints search, and they will pull the things that the state won't pull. They go deep. They go deep, 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 and far, far, far. Okay? So the third myth is that if your immigration record has been sealed, that the immigration won't see it and you don't have to disclose it. In fact, the immigration will see it and you do have to disclose it. There are exceptions and you need to talk to us about them. Right? Fourth one, and this is very, 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 very common one. I come across it all the time. People come to me, whether they're in removal proceedings, meaning they're in front of an immigration judge, or they're undocumented and we're talking about it, and they often ask me, well, it's not like they're going to deport me. I have a child who's a U.S. citizen. That's a big one. Just because you have a child, that will not prevent the immigration from deporting you. And they have deported people with small children here, and they will continue to do that. Having a U.S. citizen child does not in and of itself confer any benefits on the parent. Okay? Yes, when the child becomes 21, under certain circumstances, the child would be able to apply for you. But when a child is a child, meaning they're under the age of 21, just because they're a U.S. citizen, in and of itself will not stop or prevent immigration from deporting or removing you from the United States. Now, there are different circumstances, and there are certain circumstances where we can use a small child, especially if the child has developmental disabilities, learning disabilities, or serious medical conditions. In certain circumstances, we could use it to our advantage to prevent you from being removed or deported. But again, the fact that you have a child in and of itself, by itself, will not stop anything. And in fact, it has happened many, many times in the past. It happens now, and it will continue to happen. Especially if you already have a removal order and your child was born after the removal order or deportation order was issued, the fact that you had a child here is often viewed either neutrally, meaning it's not given any weight, or sometimes it's even viewed in a negative way, meaning like you knew you had a removal order and you still chose to continue to live here and establish your life, and chose and made a decision to have a child. So then you cannot turn around and take advantage of the fact that you had a child here. Again, please understand that's not my position. This is just what we're seeing from certain decisions, and from past experience. What is the reasoning? Obviously, the reasoning is one is birth tourism. The government doesn't want people coming here, having babies, anchoring themselves to the United States, and then being able to stay here because the child was born here, right? If you recall, during the last presidential election, there was a whole big deal made about, whether people who were born here should really derive citizenship automatically and stuff like that. That's all political debate, philosophical debate, ethical debate, moral debate. This is not what we're doing here. But so that was one of the reasons. Another reason is if your child is a U.S. citizen, they won't lose their citizenship if they go and live with you in the country where you're from. So when a person says to me, but how can my kid go with me? They're a US citizen. They won't lose their citizenship. They could go live in this country for 10 years and then come back. You can leave them here with another parent. So to the immigration, the fact that you have a US citizen doesn't entitle the parent who's undocumented or has a removal order to stay here with a US citizen child. In their eyes, if you do not want to be separated from the child, you can always take the child with you to live in the country where you're from, and then, you know, down the line when the child turns 21, see what can be done for you. So that's a very, very common misconception. Of course, whether we're able to stop deportation oftentimes depends on the policy of the president that's in office. And prime example was the change from previous administration to the current administration, and how fast things are changing and how broad our options are becoming with a more liberal approach to immigration. So some of these things, you know, will change if the presidency changes, but currently, you know, we are in these more liberal times, and we're able to help a large amount of people overcome problems and difficulties they've been experiencing over the course of the last administration. So if there's any questions that you have, or if you've been hesitant, or if you have been kind of, you know, on the verge but afraid, this is a good time to speak to an immigration attorney. This is a good time to, if you're eligible, to make an attempt to remedy your situation. A lot of things have already changed, and I'm sure, I'm not sure, but I'm very hopeful that they will continue, at least for the foreseeable 4 years, to improve, right? So that we're able to help a lot of people. I know that immigration invokes a lot of feelings in different people, but sometimes I think about it more in a way, the way that prosecutors and defense attorneys in criminal cases think about it. You may think one way or believe one way, but the law is the law, right? And we apply the law and the policies as they are currently and right now. And if you come to me and I look at your file and I tell you there's nothing I can do for you now, you may not like the answer, but I am obligated to tell you that there is nothing I can do for you. And if I tell you that, you know, things have changed and now I can do something for you, the option that I'm giving you may not be as fast or as easy as you would like it to be, because people think just because we have a more liberal administration that things are automatic. No, they still require a lot of hard work, research, dedication, you know, attention to your case. But I have noticed that people sometimes go to attorneys who give them the answer they're looking for. But that's not really the job of an attorney. I can't give you the answer that you're hoping for. I have to give you the answer that is realistically based in facts and in the law. And if I look at the case and I say, currently at this point right now, there's nothing I could do for you, or if I give you the possibilities that this outcome is happening, this outcome is happening, I'm not doing this in any personalized way. It's not personal to you. It's not because of any of the feelings that I hold. It's just based on the analysis and the fact of the law. And if there is something we could do for you, we take every case serious. If there's a fight, we will have to fight. If there's a chance, we will find a way and we will grab the chance and we will deliver the best possible results that we can for you. So I wanted to say thank you for joining us again. This video is always going to be posted on YouTube, on our YouTube channel, Cohen and Tucker Law. I know you guys are watching some of our videos have gained a lot of views, and I'm glad you're finding this helpful. And continue to ask me questions, continue to email us, continue to reach out. Even if you've been to other places and you just want one more opinion, one more perspective, reach out to us, and we'll talk to you. If we'll see if there's anything that we can do for you. Okay. As always, I always make announcements here on Facebook, and then it goes to YouTube channel. If there's any new policy or regulation that comes in, we will post it here. All right. So everybody have a great weekend. I will see you everybody next Thursday. The topic for next Thursday will be posted around Monday, Tuesday of next week. I hope everybody enjoys this beautiful weather that we're having in New York, and I hope it stays that way. I'm actually going to be visiting Arizona soon, so maybe next time I can tell you a little bit about that. Thank you, everybody. Have a great day, and I will see you in a week.